what I'm trying to do is to create something, because I think a lot of people are going to be facing what's going on right now in court. And Posr, you told me something about what, co-defending? I'm recording this right now.
Right. Yeah. You were saying that you thought that Joe wanted a lawyer for certain technical stuff that he might not feel comfortable. He may not be very knowledgeable on, but he wanted to explain certain things himself and his way.
Right.
So the sounds to me like what Joe really wants is co-counsel. That is, you know, there are many times when you'll see cases where they'll have 3 or 4 lawyers on one side.
Right.
And each lawyer will, you know, take his or her particular specialty, especially like in the O.J. trial. There was one guy he was a DNA, I forget his name, but he was, you know, his DNA was his thing.
Right.
And he did the DNA stuff. He even did summation on the DNA stuff. Now,
Yeah.
Johnny Cochran came later and incorporated the DNA guy stuff into his argument, but the DNA lawyer did his DNA thing. So that's called co-counsel. Now, there's always only one person can be lead counsel.
Right.
But there can be co-counsel. What happens though when when you didn't go to law school is, the lawyers who are defending you, supposedly, they don't want to be co-counsel with you. 2, the judge will stop them from being co-counsel with you. So even if you could find a lawyer that would be co-counsel with you, maybe the judge is going to stop you. So, but there's no law against a non-bar admitted attorney and a person who's representing himself from being co-counsel. There's no law that stops that.
Posr, has there ever been a precedent? Has there ever been a case where someone could be co-counsel?
You mean
In New York?
You mean a bar admitted attorney and a and the defendant himself? I don't even like to use the word defendant. I like the word presumed innocent, so that's how I'm going to characterize what most people call defendant, because you actually have nothing to defend. So why do you call it defendant?
I got some real good news. Let me tell you some of what happened yesterday and what happened today.
Okay.
Yesterday, I have pictures of the driveway. It was a half-mile driveway that the police came up on 2 occasions without a warrant to do an investigation to try to get a warrant, which I say is the fruit of a poison tree,
Right.
because they trespassed. Now, I said they were trespassing on private property, well-marked private property, right? And I had pictures of all the signs, the no trespassing signs, and they're very big, and there's a lot of them, right? Now, all 4 police officers stated on the record that they did not see any of these signs, right?
Right.
Now, after they testified to that, at the end, just before it was the end of the day, before we went home, I said to the judge, Your Honor, in my opinion, all 4 of the police officers lied about about the signs, not seeing the signs.
Okay, my first reaction is your opinion doesn't really matter. But go ahead.
Let me finish. And I said, and I would like to ask this court to give me subpoenas for the landlord of the property and his wife, right?
Okay.
And he agreed that he would give me subpoenas for the landlord and his wife. Then I came home and I called the landlord. I called the landlord's wife because I didn't have the landlord's number. She has a cell phone. And I asked her, would she be willing to testify to the signs, and would her husband? And she said to me, the prosecutor had called them and left a message for Arthur, that's her husband, to call him first thing in the morning. Right?
Okay.
So then this morning, she called me as soon as she woke up, and she said, the prosecutor called Arthur and asked about the signs, and Arthur told the prosecutor that those signs were always there.
Okay.
So now, when I go back into court, I'm going to ask the judge, I'm going to say, Your Honor, if the prosecutor has exculpatory evidence, isn't he obligated to give it? And the judge is going to say yes. And then I'm going to say, well, the prosecutor called the landlord of the property. Could the prosecutor, for the record, state what the landlord told him? Now the prosecutor is going to have to impeach his own witnesses and say, the landlord said that those signs were always there.
Now, yes. Is the landlord going to come in and testify?
The judge said he would give me subpoenas for him, yes.
Yeah, usually you make up the subpoena, give it to the judge, and they sign it, and then you serve it, or you get it served. But so I just find that
he agreed to give me subpoenas. He might make me, fill them out.
Right.
He agreed that he would sign them.
Okay, yeah, I just don't want you to get caught up into waiting for him to do it, and then he tells you right there on the moment, well, you give it to me, I sign it. I don't want you to get caught up in that. So what I'm just trying to, I don't know if you have a form there that you can get, or tomorrow's going to, that you make it out and give it to the judge to sign.
But isn't it today at 12 o'clock, Joe?
Yeah, 12 o'clock.
So shouldn't the landlord be there at 12 o'clock?
No, actually the judge said on the record that it wouldn't be fair to give, this is before we knew the prosecutor had talked to him, that it wouldn't be fair to give him the paper and expect him there the next day.
Oh, well, that's great. That's a good thing.
Yeah, that's great, because that means he's going to stall it.
Right. What, pardon me?
That means he's going to have to stall this trial. It's got to, or it's actually the hearing. It's a map hearing that we're having right now. It's not the trial.
Right.
On the warrant.
So,
yeah. So, well, that's good. And he actually, true, he would have to give you exculpatory evidence, certainly before trial. I don't know about a hearing. I would think that he'd have to give it to you before a hearing. But it'd be certainly good to bring it up.
This is during the hearing. It's not before the hearing. He has exculpatory evidence that shows that his own witnesses lied.
Yeah, I would think he would have to do it even like right as soon as next time you get before the judge.
Yep.
Yeah, I would think he'd have to do this. Matter of fact, he should be doing it now.
Yeah.
Because he should be giving it to you now, right now, because it's not like you get to trial and get the exculpatory. You're supposed to get it certainly in a meaningful time frame.
Yep.
So,
say, you guys, can you explain what exculpatory is?
It's evidence. If the prosecutor, like they try to say you did this wrong thing and you did this wrong thing and you did this wrong thing, but if they know that there's something that goes in your favor and they have that evidence, they have to give it to you. That's what exculpatory evidence is. For example, if let's say I was being charged with a robbery.
Okay.
Right?
Okay.
And the prosecutor has a witness that saw me someplace else at the time the robbery happened.
Uh-huh.
He's obligated. That's what exculpatory evidence is. He's obligated to tell me that, yes, we believe you did this robbery, but we have this witness over across the other side of town that says you were there at that time.
Yeah.
They can't hold back information that might clear you.
So this could come out at 12 noon?
I'm sorry, I didn't hear you.
Can that come out at 12 noon?
No, I just have to meet with the trial isn't going to start actually till 2:30. I'm meeting with my lawyer and all the witnesses. I got witnesses that are all going to get on the stand and say they came to my house before the police came and they all saw those signs.
Okay. So that's great. So Joe and Posr, is there any way you can come down with your lawyer, either what did you call it, co-counsel, on Saturday, and we do a show in the studios, really nice lighting and everything?
I won't know till after I talk with him.
Okay. Posr, do you have Saturday available at noon? I don't know if the slot's still available, but I could check.
Noon's tough for me to get down there. If I was going to do it, I might have to come down Friday night, because for me to get up and get down there...
No, I understand, but I think that's the only time I have available. I may be able to change it to 4, but I have a whole panel. But I juggle it for this.
Do you have Skype? Do you have Joe, do you have a camera? You have a computer and a camera?
I have a computer. I don't have a camera.
No, he doesn't.
Oh, because then you could have done it on using Skype.com. Actually, you have like a webcam.
Actually, I'm teaching him how to do that. I set some parts of it up, but not all. But what I wanted to do, Posr, was you have such an extensive background, and even bringing up the OJ trial and cameras in the court, that's a very, very important, because we're creating documents that many people are going to be listening to, because as this truth of the cancer cure starts to hit, you can expect there's going to be more litigation, and people need this information.
Yeah.
And so that's what I'm saying. If we could get Joe, his lawyer, get you, Posr, in the studio, we could really do some very, very important work.
Yeah. What day are you talking about?
Well, I was hoping Saturday, but I'm not completely sure that it's still available. I could check on it.
Saturday's going to be, I can't. I'm obligated.
Okay.
I'm obligated.
When could you? Because see, if this trial comes up on the 28th, and if really horrible things happen because we live in a police state, I mean it seems great so far, but just to prepare for the worst, it'd be good to get as much footage as we can.
Yeah, but I'm kind of committed until June 23rd.
Okay.
I may be freed up before then, but I have another priority getting these papers filed that I'm in the middle of.
Okay, but at least you can get the motions for this one, the Kingston trial on the 28th.
Yeah, for the camera. Yeah, that.
Okay.
That I can do, but
Okay, well, I'll try to patch it together, because Joe Posr's experience is extensive, and he saw over the horizon a few years back and even went to jail for it. And cameras in the court would have shown, even in his own case, in his own trial, how misjustice happened, how it was a mistrial.
I got a question for you, Posr.
Okay.
If the prosecutor says that the landlord said the signs were always there, and I put 10 witnesses on that say that they saw the signs, you couldn't miss the signs, they were obvious, and can I ask the judge to throw out any of the testimony that the police gave, or
No,
can I ask him to dismiss this case on the fact that they lied?
No, that's going a bit far, but you can still get it dismissed as true to poisonous tree on the basis that the signs were there, and that on the basis that the signs were there.
That, in other words, they didn't have a warrant in order to get a warrant, right?
Right. Right.
Yeah, I guess you could put it that way, but that line, perjury is it's not that they contradicted themselves. Then you can start asking for perjury, but their claim is, I was looking over to the left when I saw, maybe I was looking to the left when the sign was on the right,
The signs were on both sides of the driveway, all the way up.
Really silly, stupid things, like, I might have been looking at the speedometer when I was going up, or looking in the rear view mirror. Perjury is kind of difficult, but if you can establish that the signs were there and that they should have seen them, which brought me to another point, because did you get the pictures? You didn't get the pictures of the signs into evidence, did you?
I got them as exhibits.
Right. Now, when, because you know, in these kind of hearings, you can testify too, you know.
Yeah, I know.
But you really want to get the pictures into evidence.
Yeah, after I got off, he's had two lawyers standing by just in case he decided that we couldn't try it anymore. He was going to have them step in. So they've been standing by.
So where were those lawyers standing when the proceeding was happening? Were they in the well with you?
No, they were in the back of the court.
So your standby counsel is not in the well right at the table with you?
He's not standby counsel. What he wanted him to stand by in case I can't handle it. They would have followed the case. They're not allowed to say anything or put any...
This is my question. When you're in the well, right?
Yeah.
Who else is in there on your side with you?
Me and my son, that's it.
You should have... No, see, in criminal proceedings, you get what's called... Yeah, those lawyers should be actually sitting at the table with you so that you can ask them legal questions.
He said I couldn't do that.
Oh man, he's a damn liar. You know how many I have gone through? Let me see, at least 17 criminal proceedings, right?
Yeah.
Most of which I won. And in each time, I had counsel sitting right next to me that I could ask them legal questions. How do you do this? What does that mean? For that judge to actually, I'm just, see, there's nobody there, and there's nobody that can take a picture and record it. I'll bet you if you get the transcript, it would be empty of that statement that they couldn't be there.
Whoa!
It would be empty of that statement. I've done at least 17 different ones. Every time I had a bar-admitted attorney who was standby counsel, because he's there to legal assistance, not just to take the case over, but he's there to answer legal questions. And,
right.
I can't come up with a solution right this moment, but you need to think on that one, how you can stress that, because that guy should be standing right there in the well with. Now, it's unusual that he lets your son is charged too, so that's why your son could.
Yes.
But that lawyer, you are able to ask him legal questions. I don't have the law on that, but hey, I have experience-wise. He's supposed to be here. Think on that and get him in there so you can ask him questions, because you really need to get those pictures into evidence. I would want to get those pictures into evidence.
Now I know how to do it. After the case was over, it wasn't over. After it ended for the day,
yeah.
When we went out into the hall,
yeah.
My son's lawyer, who really knows map hearing well, right,
Yeah.
said it was like watching a baby choking and you couldn't do nothing about it. He wanted to scream out what I should do, because he was seeing me having trouble getting them admitted as evidence.
But
right?
but Posr is saying you shouldn't have had to scream out. He should have been sitting there in the well with you, right by your side.
I understand that. But then when we went out, he told me that what I should have done was showed the exhibit, and then when they commented on it, then said I would like this exhibit put into evidence. I didn't know to do that. Now I do know to do that. When I put my witnesses on, I can show them these pictures and say, now I would like to submit this as evidence.
Okay, let me just talk one thing, right? When you're trying to put something in evidence, a picture of something, there's something called authentication. if I had taken the picture
Yeah.
of the sign,
Yeah.
I could authenticate the picture that I was standing such and such a place, such and such a time, and I took that picture.
Yeah.
Right? I could authenticate. Someone has to authenticate the evidence that's coming in. The police officers, because they're saying they didn't even see it, they can't really authenticate.
Right.
Oh, right. That's
Because they didn't even see the sign.
right.
So they claim.
Right.
Right.
But a person who actually saw the sign could authenticate. Well, see, now you got another problem because you took the picture.
No, I didn't say I took the pictures. I said I have pictures.
Oh, well, you got to.
One of my friends took those pictures.
Okay, you should be really careful about that because when you start to put a picture in, usually it's the person that took the picture that you need to get the picture into evidence.
Right, which I'm going to do.
Well, who would be ideal? The landlord? Can you get the landlord to take the picture?
But the picture's already taken.
Right.
So
I'm going
you
to.
can even get new pictures. You can get a new picture, right? You can get a new picture,
Right.
and you could authenticate it, but you have to be on the witness stand to authenticate.
Yeah.
You have to be the witness.
Right.
And in my hearings, you can testify.
I know.
But you know, maybe you don't want to. But just you got to be careful because usually it's the person who took the picture who authenticates the picture.
Yeah, I'm going to talk to the person who took the picture and see if I can get them to come in and authenticate them.
Well,
Yeah.
Posr, what if I come up and take a picture and put it on Manhattan Neighborhood Network and all my viewers can come in and authenticate it? No, they couldn't authenticate taking it, but I could go up there and take it.
Yeah. Then you gotta. Yeah.
But I can't do it by 12 noon.
Yeah. And then you gotta say, first you have to mark the thing as an exhibit. You say, Your Honor, I'd like to. Your Honor, well.
They have all been marked as exhibits from. I got from A to L, exhibit A to L.
Yeah. Damn, that many.
Yeah.
You got that many pictures?
Yeah, because there was a lot. My driveway was a half-mile driveway, and there were signs on the driveway about every 30 feet.
Wow.
And when you came into the driveway, there's 4 signs. As soon as you pull in the driveway, there's 2 on each side of the driveway, facing the. You can't miss them. They're big signs. They're not little tiny signs tucked away on a tree.
Tucked
Right
away.
up next to the driveway. And there's 4 of them. As soon as you if you pulled right into the driveway and stopped, as soon as you came off the road, there's 4 signs. You can't miss them. Then, with a half-mile driveway, as you drive up the driveway, about every 25 to 30 feet, there's another one. And it's a half-mile driveway. So they're trying to say that they probably went past 15 signs that they didn't see.
Highly unlikely.
These are trained police officers who are trained to be observant.
Yeah. But you gotta be looking at what did they say they came in the daylight or nighttime?
They came in the day. And they came twice without a warrant, right?
Right.
And the 3rd time they came with a warrant.
Based on the 2 times without a warrant.
Right, 2 times without a warrant, seeking evidence to get the warrant.
Yeah, I wouldn't even open my door. I would never even gone out there.
Okay, the first time they came, we were outside, and they pulled in, and they were playing this game with us like, we're looking for a lost road. And what they said in their paperwork was, they came to identify the house and to, since they were going to raid the house, they wanted to come up and see it, see the location, and they came up in the day, and they said, we're looking for a lost road. And me and my son told them, we don't know that road. We never heard of that road, right? Then, a couple days later, another officer came in plain clothes, and he came up and he knocked on the porch door. When he knocked on the porch, I stepped out on the porch and shut the door behind me, right? And he said he had a picture of a dog and a number, and he said, I'm looking for my lost dog. My kids are missing this dog. Can you help me? And at the time, I didn't know it was a cop. So I said, I looked at the picture and I took the number and I said, yeah, if I see the dog, I'll call you. Now he said when I came out on the porch, he smelled marijuana on me and emanating from the house, and on that he got a warrant. And what started the investigation was an anonymous informant told him that I was growing marijuana.
So, Posr, I think the point is that all viewers should realize if there's the smell of marijuana on them, they're susceptible to be getting a warrant. And I think that's the importance about this trial in Kingston on the 28th, is that if we don't free the marijuana prisoners, we might be next. And I don't even smoke it. They might say they're smelling something emanating from me.
Yeah. I love you, Paula. You got it. We got to free the marijuana. All the nonviolent drug offenders, not just the marijuana. We start with marijuana, but after that, we got to free all the nonviolent drug offenders that are in jail.
Right. But I mean, Posr, what do you think about that? You didn't make a comment about you're getting a warrant because somebody smells marijuana emanating from them, and you get a warrant.
Well, first thing I think of when somebody talks about anonymous is how reliable is the information. As a matter of fact, they have to deal with that too, because there's a thing called reliability. Like like some informant can't just go, X, Y, Z. The informant has to be reliable.
Right.
So how in your hearing did they even demonstrate the reliability of the anonymous phone call that they got?
Right.
Did they ask the person, well, how do you know? Did they even try to identify the person? What procedures did they go through to determine?
They asked the person their name, and the person said they wanted to stay anonymous.
Did they ask the person how the person knew that there was marijuana on the property?
Yeah, well, she said she saw it when she said she saw it when she came to pick up her daughter, which is a total lie. I know who the anonymous informant was. It was a girl.
No. What she said. She said when she came to pick up her daughter from what? From the house?
Yeah.
So she's claiming that she had her daughter in. Are you the only one that lives in the house?
Me and my son were the only ones living in the house, but her daughter was never there. Her daughter's in California.
So she claimed that she came to pick up her daughter. Now, and did you get a copy of the recording? Because was it recorded? Their phone conversation with the person?
I asked them, and they said no. But the police officer took notes of the conversation.
You didn't actually do a written FOIL discovery request, because it came on 911.
No, she called actually Urgent Task Force is the local gang that busts people.
Oh, tell them who's the head of Urgent.
The head of Urgent is a guy called Dirk Budd.
But I thought the judge funded it, Posr. There's a big...
The judge in my case raised funding for Urgent.
Sounds like a possible conflict of interest.
I asked him that. I said it's a conflict of interest. Would he recuse himself? And he said, no, I can be impartial.
That's what they always say. But then also, you didn't actually like put it in writing as a motion that he had to respond to. Like
Yeah, I did. Yeah, I did.
Oh, and did he deny it on paper?
Yeah.
Oh, okay. That's good.
Oh, I buried, believe me, I buried them in paper. I don't think they have ever gotten as much paperwork. None of my motions were were less than 30 pages. And some of them went to 60 and 70 pages. And I put one in. For 14 months, I kept putting in paperwork and putting in paperwork and putting in paperwork. And the prosecutor would not answer my paperwork. None of it. And then after 14 months, I put in a motion asking to have the case thrown out because a speedy trial, and the prosecutor caused the delay by not answering my motions. And they tried to say that the reason I shouldn't get speedy trial is because I kept putting in motions. And I said, I was forced to keep putting in motions because I put in a motion, you didn't answer it. So I put in another motion asking almost basically the same questions but phrasing it a little different. And then you didn't answer it. So then I put in another motion. And he never answered my motions.
Wow. You know, when you put your case, Joe, next to Posr's, this is going to be a really, really important combination for people to know about. To realize how we have a Constitution that could be so great, and yet if we don't use it and exercise it, we're not going to keep it. We're going to lose it.
The first thought that comes to my mind, and we still haven't gotten to the daughter who wasn't never at the house. But the first thing that comes to my mind when you talk about you kept putting in motion is if they did not answer the motion, then they cannot claim time for the motion. Only if they had answered it could they then say, well, we needed time. Because if they didn't answer, what did they need the time for?
No, they're saying each time I put in a motion,
So
it delayed the trial.
I understand that, Joe. What I'm saying is, my retort to their claim is, well, if you didn't answer the motion, therefore, that you didn't, the time is still on you because you never answered. You can't claim you needed time. You can't claim the time is not on you if you didn't answer the motion.
That's I already did that. I already said that. And they still refuse to throw it out on speedy trial.
You know what they did, Posr? They compared it to a murder trial that took 17 years. And they said, therefore, we can't dismiss this on speedy trial.
Right. I cited all these cases on speedy trial. And in New York, they're supposed to get you to trial within 6 months. And the judge said, well, the prosecutor said he was ready for trial way back in the beginning. Therefore, he was ready for trial. Once he said he's ready for trial, speedy trial no longer applies. And the prosecutor said, after I put in all these law cites on speedy trial, the prosecutor came up with, well, there was a murder case in New York, and it took 17 years for it to get to trial, and that was ruled that it couldn't be thrown out on a speedy trial. And I said, I'm only charged with a felony, and murder has no statute of limitations, but other felonies do, and they ignored it.
Yeah, I mean, you know, this woman, the daughter that was picked up.
The daughter was never picked up. She was never there. The daughter never left California.
Now,
I never met the daughter.
Yeah, because reliability is one way you always can challenge an anonymous call.
Right.
So, so she said she came to pick up her daughter and she saw it. Even
it was growing in the house. Actually, how she saw it is she had been an ex-girlfriend from 18, actually now 20 years ago, and she called me from California and said she was getting evicted and her boyfriend was beating her up and she had no place to go. And I sent her $1,200 and said, well, come to New York, because she was afraid that the boyfriend might hurt her. I said, get out of California. Come to New York and I'll help you get a place. And she came to New York and she stayed with us for 2 months while she was looking for a place. And I loaned her money to help her get a place because I wanted to get her out of there because she had these 2 vicious dogs and my landlord didn't want the dogs there. And she was a pain in the ass anyway. And so I helped her get a place, and then she got a place. And then after she got a place, she came back to me and tried to blackmail me, saying that she wanted money or pot for... Now, the daughter that she's talking about, 18 years ago, she got pregnant. She was my girlfriend. 18 years ago, she got pregnant. But she was sleeping with another guy. And she told me she didn't know whose kid it was, mine or the other guy's. Then she came back, and I said to her, because I wasn't going to keep her as a girlfriend, she was cheating on me. And I said, I'll tell you what, I'll pay for an abortion. She didn't want an abortion. Then she comes back after the baby's born to show me the newborn baby, and she says to me, I had a blood test, it's the other guy's. The other guy married her, and they moved away. I didn't hear from her for 18 years. Then she goes through this thing where she's in trouble. She moves back here. Then after I help her get an apartment, she comes back to me and says, when are you going to pay me for 18 years back child support? The kid is yours. And I want 18 years back child support. Now the kid's 18 and living with her boyfriend. And the other guy married her and paid child support for all those years, right? So I told her, and especially after I had helped her, I said, and she said, you don't want me to go to the police and tell them what you're doing. You should pay me either in pot or money for 18 years back child support. And I said, you know what? As a friend, I tried to help you. And if you'd have come to me as a friend and said, Joe, I need some help, I would have loaned you money again. But when you try to shake me down, fuck you, you're not getting a penny out of me.
Let me ask you a question, right? Did the police say that why they didn't try to get a warrant on the anonymous phone call?
What's that?
Okay, so there was an anonymous phone call, allegedly.
Yeah.
Why didn't the police try to get a warrant on the anonymous phone call?
Because she probably wouldn't sign it.
They have to substantiate it. They can't just... They have to substantiate it.
No. Did they say why they didn't try to get a warrant?
No, they didn't.
Because you can, just because it's... Like I said, they could have went to a judge and said, look, so-and-so called us and said she was there with her daughter and she saw, some herbs growing in the house. They could go to a judge and put that to a judge. But then a judge would say, he probably would say, well, who was this person? How do we know it's not a prank? What do you mean there was the daughter? Who was the daughter? Have you talked to the daughter? Because they should have did that too. Because the anonymous phone call has to be kind of reliable.
Right.
It's got to be. Now, if you said, when you get an anonymous phone call, hey, somebody's being shot, stabbed, that's, But they should have, there's a reason why they didn't get a warrant on the anonymous phone call itself.
Right.
And that goes to the weakness of even coming on your property. Yeah. Now, it sounds to me like you're going to be all right because you got all these signs, you got people going to testify, and you really, I would make that subpoena up. I don't know how far the judge is from me, but I would make that subpoena up and bring it to the judge today so he can sign it and get it signed on the landlord. And get it served on the landlord.
Yeah.
That's what I would do.
Yeah.
That's
what I intend to do.
Yeah, I do that today. And also I would ask the judge for permission, because usually the person themselves cannot serve a subpoena.
Yeah, I have people that'll serve them. I don't have a problem with that.
Yeah, so get an affidavit, notarized affidavit from the servant. But so that's what I would do. I'm going to have to get ready to get out of here.
I understand.
Me too, pretty soon, but when he gets off, I'd like to talk to you, Paula.
Okay. See you, Posr. Posr, I'll be in touch. We got to figure out some way to get you in the studio, because you've got such a great, important story.
Thank you, Posr.
Okay, thank you, Joe. We'll touch base again.
Okay, bye. Hang on, Joe.
Bye. Yep.
I can't remember who I dialed first. Joe?
I think me.
Okay. Do you want me to cut the camera or keep it going?
No, yeah, cut the camera.
Okay. So, Posr. How do cameras in the court help this?
Really put it in a nutshell, it's a big statement that's hard to digest and to wrap your mind around. But in fact, if litigants and the public were allowed to have cameras in the court, justice would occur where injustice occurs now.
Now you're putting your money where your mouth is. You're actually taking steps to have documents and file motions. And for the novice who doesn't know anything, like myself, for my court case, I had a trial. It took me 5 rounds going to court to actually get the trial. I think it's going to actually happen on the 13th of October. And I connected with you and I said, hey, what about making a motion for cameras in the court? Because I heard you talk about that.
Well,
can you tell us what you prepared?
I have the motion here. Actually, you can see it, and well, that's the first page of it.
Okay.
It was just filed. Let me read it to you. And this is in the Civil Court of the State of New York, County of New York, the Housing Park at 111 Center Street. And it says, please. This is the notice page. It says, please take notice that I, Posr, have been contracted by Paula Gloria, respondent, to video record all further proceedings, namely the proceedings on October 13th, 2009. And I will respectfully move this court on October 13th, 2009 at 9:30 in the forenoon in a courtroom not yet announced by the court, located at 111 Center Street. We have a little justice being administered
kind of by the people.
By the people at this moment. I'm going to move the court located at 111 Center Street for an order granting permission pursuant to 1. 22 NYCRR 29.1B2, pursuant to B, the Fifth Amendment right to pursue the profession of video court recorder. 3, pursuant to a litigant's First Amendment right, entitlement to freedom of speech to video record, his or her own speech. And 4, pursuant to the entitlements and principles of the doctrine of checks and balances, and referred to in the unenumerated entitlements of the Ninth Amendment, to audio-visually record for the purpose of providing a check and a balance against A, lost tapes and or transcripts, B, altered tapes and or transcripts, C, incomplete tapes and transcripts, which necessarily do not record non-verbal language, body language, which is evidence according to the New York State Law of Evidence, which is in close accord with the Federal Rule of Evidence 801D. That's the notice page of the motion. And every page has 3 parts to it.
What about the costliness? To get a transcript, I thought you mentioned.
The costliness is another aspect. I actually neglected to put that on the notice in the affirmation.
Okay, I'm sorry, I'm jumping the gun.
I believe, yes, I talk about expensive records. Because people actually get priced up. But I'm gonna read it through once just so that you get it, and then talk about what's there. So that was the notice page. Each motion has a notice page where you notice you want the court and your adversaries to take notice that you are going to move the court on a particular date to do a certain thing. Then comes the affirmation, where you affirm certain facts under penalty of perjury. And what we have here is an affirmation in support for permission to audio-visually record by none other than the respondent, Paula Gloria. And she says, I, Paula Gloria, the respondent, am familiar with the facts and the circumstances of this case, and I confirm the following under penalty of perjury. I have contracted Posr to audio-visually record all further proceedings pursuant to 22 NYCRR 29.1b2, pursuant to the Fifth Amendment right to pursue the profession of video court recording, pursuant to a litigant's First Amendment entitlement to freedom of speech, to video record his or her own speech, pursuant to the Ninth Amendment, and pursuant to the New York State Rule of Evidence that identifies non-verbal evidence as potentially relevant and admissible. Due to having, and this is Paula's statement, due to having heard many, many stories of altered, missing, lost, stolen, unavailable, and or expensive records, I have contracted to independently protect the record. Now we get to my affirmation. Where I, as the contractee, make factual statements. I'm Posr, the proposed intervener, and I am fully familiar with the facts and circumstances surrounding the contract between the respondent and the proposed intervener, calling for the proposed intervener, that's me, to video record the proceedings in the above referenced case, and I state under penalty of perjury, I have been contracted to video record the proceeding in the above referenced case. Fifth Amendment. The Fifth Amendment grants the proposed intervener the right to engage in a legal profession, and the recording of court proceedings is legal. See Green versus McElroy, 360 U.S. 474, 492. Schwer versus Board of Bar Examiners, 353 U.S. 232, pages 238 to 239. State-imposed restrictions on this right to engage in a legal profession must be rationally related to a legitimate state interest. See Schwer, that's at page 239. The legality or illegality, or the legality or lack of illegality, can be seen in the decisions, that is, the legality of video recording, or the lack of illegality in video recording, can be seen in the decisions and orders of New York State judges who have, since the enactment of Civil Rights Law Section 52, which was back in '98, who have, since the enactment of Civil Rights Law 52, and continue presently to permit the video recording of proceedings for press purposes without having been arrested or fired for permitting such recordings. That is, no judge has ever been arrested in New York State for allowing cameras in the court. So how can anyone claim that it's illegal unless they're saying that the judges are breaking the law? New York State has seen fit in 22 NYCRR 29.1b2 to grant litigants the right to record proceedings for litigation purposes. Protection of the record against loss, theft, incompleteness, and alteration are legitimate litigation purposes for which to video record proceedings. First Amendment. Each citizen of this nation has a First Amendment, Ninth Amendment right to contemporarily telecast his or her own speech. The only way for a respondent to actually contemporarily publish his or her speech, both verbal and nonverbal, right? Because you have verbal speech, you have nonverbal speech, is to permit the video recording and telecasting of speech. It is therefore incumbent upon plaintiff or the court to subject the portion of Civil Rights Law 52 that prevents a testifant and party from contemporarily telecasting their testimony, to subject that law to the strict scrutiny test. What is the strict scrutiny test? Whenever it is determined that legislation significantly interferes with the exercise of a fundamental right, the First Amendment is fundamental, a court must review the legislation with strict judicial scrutiny. See Kramer versus Union Free School District, number 15, 395 U.S. 621. See Shapiro versus Thompson, 394 U.S. 16. See Skinner versus State of Oklahoma, ex rel, 316 U.S. 535. Under this heightened standard of review, that is the strict scrutiny test, the state must demonstrate that the statute serves a compelling state interest, and that state's objectives could not be achieved by any less restrictive measures. What does that mean? What is a compelling state interest? Well, certainly if someone was pointing a gun at someone and threatening to kill them, that would be a compelling situation. If a building were about to fall down, if someone were about to be run over by a car, that would be a compelling situation. But when we talk about the courtroom and filming in court, the question must be answered: what danger does cameras in the court present? That's the question. Now, we know that in almost all states, and even this one, where supposedly the law prevents a judge from having a camera, you have cameras in the courts without any danger. So, where's the compelling interest? Where's the danger that you have to stop when there's a camera in the court? That's the question that must be answered in the strict scrutiny test. Because remember, the First Amendment gives a person the right to telecast his or her own speech. That's a fundamental right. So now the state has to come and present a compelling reason to stop a litigant from telecasting their speech on the witness stand, their own speech. I'm not talking about filming some other person. I'm talking about a person who's there, who is a witness, telecasting their own speech. Okay? So that nobody else's rights are infringed upon.
Or defendant.
Or a defendant. If a defendant wants his testimony to be telecast, that's his speech. And he's got a right, a First Amendment right, to have his speech telecast. Unless the government can come up with a compelling interest in stopping that free speech. But then there's a second part to the strict scrutiny test. Even if a compelling interest is announced and identified, the state must then show that the speech was curbed in the least restrictive way. What does that mean? Well, first you have to identify what the danger is. Then you can only infringe upon my free speech right to the point that the danger is eliminated. For example, let's say there's a compelling interest in not showing jurors, which I don't think there is because everybody has a right to see them, but let's say there was. Okay, so that means the least what do? You don't stop a person from filming. You actually make some sort of a structure so that they can't be filmed. That would be the least restrictive way. You could give a judge a button that turns the camera off whenever something's happening that is endangering someone. I don't think anybody being shot by a camera has ever resulted in anything like very dangerous.
Well, when they go strike that from the record, what's that mean?
Yeah, when they say strike that from the record, they actually put in the record, strike that from the record, but it's still there that it's stricken. And everybody sitting in the courtroom already heard whatever it is that's supposed to be stricken. So if people in the courtroom can see it, and then you get to the point of, well, strike what from the record? What are we striking from the record? Did the person actually say something or do something that the judge is claiming they did? Well, when you have a camera there, whether or not the person did what the judge is claiming he did would be verifiable because you have a visual and tonal record. So that's called the least restrictive measures test. And so, and what further what I wrote in here was, under no circumstance can it be demonstrated that a compelling interest, if one can be claimed, could not have been achieved by a less restrictive manner. There's a million things that could have been done to reach any interest they claim to be protecting before you had to ban the camera from the court. Because remember, the First Amendment said Congress shall make no law abridging the freedom of the press. But here we're not even talking about the press. We're actually talking about a person's right to publish their own, a free speech right. And in 22 NYCRR 29.1b2, we're talking about a litigant's right to protect the record. But because records have been lost, stolen, altered. I know several people who have had their transcripts altered, myself included. When Peter Fokianos, whose picture I should have, but when Peter...
I'll get it on post-production.
When Peter Fokianos claimed that he was a federal marshal, a United States marshal on a witness stand in that building, that tall building right there, back in 2006, and again in 2007, I believe, when Peter Fokianos, he's a court guard in there, and he claimed to be a U.S. Marshal on the witness stand. When I got the transcript back, because he had a marshal's badge, and he pulled it out of his wallet and said, "See, it has the blue in the middle." That statement that, "See, the marshal's badge has the blue in the middle," was taken from the record. It wasn't there. And the reason why that court reporter altered the record is because it is a felony
to lie that you're...
to impersonate a federal officer. It's a felony. So that was taken out. But if I had had a camera there, Peter Fokianos would be at least under a little pressure, because we know that law enforcement and judges simply seem to be protecting their own. Checks and balances. The litigant has a 9th Amendment right to check and balance the alteration, incompleteness, loss, theft, and the expense of the record, because the 10th Amendment does not reserve video recording of court proceedings to the federal government. And New York State cannot trump the First Amendment right to telecast one's own speech in court under the guise of protecting the litigant from him or herself. Attempting to do so flies in the face of self-determination. Article 2, Section 2 of the New York State Bill of Rights prevents the exercise under any pretense whatsoever of state authority over the citizens. So if the state claims to be protecting me from myself, that is an exercise of authority under the pretense. Because the state can't protect me from myself when my free speech is what will protect me, not the state who's trying to persecute me. In addition, records can be and have been altered, lost, stolen, and incompletely recorded. It is simply common sense that any free individual has the right to provide him or herself with a check and balance against these disadvantages. Wherefore, I respectfully request the court grant this motion to record on both grounds and for whatever other relief this court deems fit and proper. Since 1994, I've studied very closely the ins and outs of cameras in the court. The so-called laws, the so-called reasons why cameras in the court are not allowed. And usually what we find is that the experts are usually the only ones consulted. You hardly ever see someone consulted who is not a lawyer or not a judge. When print media, when a story appears in print media, it's quoting someone who's a judge or a lawyer, maybe a press person, maybe sometimes. But what is conspicuously left out are the people who claim to be injured by camera-less courts. Completely devoid. You never see it. One of the most frequently given reasons why cameras should not be in the court is because lawyers would then grandstand. Every courthouse in that building has a lawyer who grandstands even though there's no camera there. But yet people still keep saying lawyers will grandstand, even though lawyers are grandstanding without cameras. People talk about, oh, it's a private, you know, they have the right to be anonymous. They don't. Because the reason why there are public trials is because way back in English history, what they had were secret trials. You couldn't talk. You couldn't get evidence. You often wouldn't even know what you were charged with. And all of this because it happened in a secret court. But people still give that reason, well, it's not everybody's business what happens in court. When in fact, it is everybody's business what happens in court. Because that is your protection, if you're innocent. Now, if you're guilty, nothing's going to protect you. If you're guilty. But what we are talking about here is protecting the innocent. This whole system is actually theoretically set up to protect the innocent, especially to protect the innocent who happens to be an unpopular person, a person with a view that is counterculture, a person with a view that opposes authority, a person who might stand and tell a judge, you're a criminal, and who has the evidence right there, but no one can see it. See, that's why cameras in the court are needed. What do you think about cameras in the court, sir? You look like a upstanding lawyer. You see that smile on his face. Now, what did that smile tell you? You might think he just thought it was humorous, the idea of cameras in the court. But you see, and this is an evidentiary perspective. Suppose he was on the witness stand and was asked that question, or some other question. And suppose he didn't smile, but instead he went like that. Now, that look, which I just gave you, looks like a look like, oh shit, I've been caught. I've been caught. Now, that was an expression which would be captured with a camera. So when you go to summation and you're talking to the jury, if you were a prosecutor, or whoever you were, if you could use it, you could then play that back for the jury and say, remember when I asked him that question and he gave that furtive look? And then you play that look again to the jury. If you don't have a camera, you can't play that look. You could talk about it.
So it's harder to sway a jury.
It's harder to sway a jury, but expressions are evidence. They are speech. And what if somebody on the jury was looking at the questioner and not the witness when the witness did that look and missed the look? Then when I refer to that, if I had no camera and I were making a summation, I couldn't talk about, that person wouldn't know what that look was because he didn't see it. But if I have a camera, then I can show him or her, that juror, that look. It could be the difference between winning or losing a life and death case. How many judges have been asleep on the bench? How many defense lawyers in capital cases have been asleep during the trial? A camera would catch that more than you think. Or it doesn't make the front page news because everybody's afraid of judges. They think lawyers are gods, and they let them get away with all kinds of shenanigans. You've got judges being mean, ornery, unruly, but you can't sue them when they actually knowingly break the law. You can't sue them when they're sitting on the bench. Even if they break the law knowingly and willingly, you can't sue them because they have absolute immunity. But if people could actually see the judge when he's breaking the law, when someone presents a law to a judge and the judge says, you can take that up on appeal, he's breaking the law. He has no answer for it. So he tells you take it up on appeal. But if you could sue him, he probably wouldn't give you that answer, or he'd give you a reasonable, lawful answer. You know, I haven't dealt with cameras in the court seriously for about maybe 8 months now. I'm just starting to get back in, and these are just coming off the top of my head. Once I get into it and break it down, you'll easily see how justice will result if cameras could be in the court. We would then have the true administration of justice, which is the firmest pillar of good government.
Thank you, Posr.
Thank you. Justice will result if cameras could be in the court. We would then have the true administration of justice, which is the firmest pillar of good government.
A person on a jury has a right to come up with a just verdict, even though it goes against what the judge is saying. But you're not allowed to tell the jury that.
Let's take the case of housing. There was no moment in the history of the world prior to this one when we had the massive capability of building houses of the highest quality, the greatest beauty, the greatest durability, and the lowest cost. And yet, a great bulk of people who once could have had houses can't have them anymore.